I'm Stephen Koprince, Managing Partner of Koprince Law, LLC. And I'm here today with the first of what I imagine will be many updates on the aftermath of the Kingdomware Technologies Supreme Court decision. The VA has released what it calls an acquisition policy flash, providing guidance to VA contracting officers on implementing the Supreme Court's Kingdomware decision. The policy flash suggests that the VA is in fact moving quickly to implement the Kingdomware decision. And if that's the case, it's good news for SDVOSBs and VOSBs. The policy flash begins by reiterating the Supreme Court's major holdings, namely that the Rule of 2 applies to orders placed under the GSA schedule and applies even when the VA is meeting its SDVOSB and VOSB contracting goals. The policy flash states that the VA will implement the Supreme Court's ruling in every context where the law applies. As a general matter, the policy flash instructs contracting officers to conduct robust market research to ensure compliance with the Rule of 2. The policy flash continues, and I'll quote here, "If marketing research clearly demonstrates that offers are likely to be received from 2 or more qualified, capable, and verified SDVOSBs or VOSBs, an award will be made at a fair and reasonable price, the Rule of 2 applies, and the action should be appropriately set aside in the contracting order of priority set forth in VAR 819-.7004. Contracting officers shall also ensure SDVOSBs or VOSBs have been verified in VIP, that's the Veteran Vendor Information pages, before evaluating any offers or making awards on an SDVOSB or VOSB set-aside. Supporting documentation must be maintained in the contract file and electronic contact management system." With respect to acquisitions currently in the pre-solicitation phase, contracting officers are to continue with existing SDVOSB and VOSB set-asides. However, if the original acquisition strategy was not to set aside the acquisition for SDVOSBs or VOSBs, a review of the original market research should be accomplished to confirm whether or not the Rule of 2 was appropriately considered. If the review finds that the Rule of 2 is met, then the action shall be set aside for SDVOSBs or VOSBs, again in accordance with the contracting order of priority. Perhaps most intriguingly, the VA is instructing its contracting officers to apply the Kingdomware decision to requirements that are in the solicitation or evaluation phase. For these requirements, a review of the original market research in VA Form 2268 shall be accomplished to confirm whether or not the Rule of 2 was appropriately considered. If the review finds that there are 2 or more SDVOSBs or VOSBs, an amendment should be issued that cancels the solicitation. However, the agency can continue with an existing acquisition if there are urgent and compelling circumstances and an appropriate written justification for doing so is prepared and approved. The VA apparently will not, however, apply Kingdomware to requirements that have been awarded to non-veteran companies, even where a notice to proceed has not yet been issued. So if there's been an actual award, a contract in place, those contracts will continue. The policy flash states that contracting officers shall coordinate with the HCA, OGC, and OSDBU and be prepared to proceed with issuing the notice to proceed if issued within 30 days of this guidance. Overall, the policy flash seems like a positive step for veterans, both in terms of the speed with which it was issued and the decision to apply Kingdomware to existing solicitations, except where an award has already been